When people think about human rights in Europe, they often think of the European Union. But long before the EU had any real human rights machinery of its own, another institution was already shaping how democracy, the rule of law, and individual freedoms were protected across the continent. The Council of Europe and the European Court of Human Rights have quietly influenced everything from free speech and fair trials to minority rights and state accountability. Yet today they face growing political pushback with accusations of overreach and even open defiance from some member states. So, how did these institutions come to play such a central role in post-war Europe? Why have they mattered quite so much? And what challenges now threaten their authority and future? To discuss all this, I'm delighted to be joined by Dr Andrew Forde. Now an academic, he spent many years as a human rights advisor at the Council of Europe. So, hi, Andrew. Thanks so much for joining us. I guess the best place to start is to give a bit of an overview of the Council of Europe. It's a body that I've certainly always felt should have got more attention than it has. And, you know, there is obviously that great confusion that comes in with the European Union, not least of all caused by the fact that they share the same flag and emblem. But I know the Council always says that it was theirs first. But perhaps you could explain a little bit about how it came about, what exactly it does, and maybe a little bit about how it's evolved. And of course, its other main institution, the European Court of Human Rights.
Great. Thanks, James. Really pleasure to be on. I suppose it's really important to make that distinction, first of all, that the Council of Europe is not the European Union, completely separate institution. It was very much central to that post-war institutional order where 10 states came together. And really the mission was about trying to promote greater unity between the members. And it was anchored in this idea of a kind of democratic security, even though that term wasn't used at the time, which really implied human rights, democracy, rule of law, and so on. You're right to say that, you know, there's a lot of talk about the flag and so on being the Council of Europe. In actual fact, that is true. Of course, the European flag was a Council of Europe, I suppose, emblem. And in actual fact, until probably the 1980s, there was actually an office in the Council of Europe in Strasbourg that had to approve every usage of the European flag by the European Union. Now we've come a long way since then, but it's just to give you a sense of the background. So the Council of Europe, I suppose, is very rapidly after it was established, it created a legal regime, and the anchor point of that legal regime was the European Convention on Human Rights. And this convention was very much based on the Universal Declaration of Human Rights, which had been adopted by the by the United Nations. Just prior to this. But in a sense, the ECHR was the first attempt to give legal effect to those rights, because the UDHR wasn't actually legally enforceable. The ECHR was going to be. And what was really, I suppose, groundbreaking, revolutionary even at the time, was that the ECHR established a control mechanism, a court, an independent court that would adjudicate on and interpret the rights that it provided for. I mean, it provided for a vast range of rights, you know, from right to life, prohibition of torture, freedom of assembly, private family life, fair trial, you know, non-discrimination, and so on and so forth. And the reason I'm sort of spelling them out is they are, in a sense, accepted nowadays as almost automatic rights, you know, that we possess them naturally, that they're so well embedded, we don't even realize that at a certain point in time, it was a bit revolutionary to put that down on paper. And particularly that an individual, you or I, could hold our state authorities to account directly. So I think that's a really important context to remember, that this was a revolutionary project in the post-war period. It was all in the spirit of trying to ensure, I suppose, unity, to avoid a situation where we would retreat to conflict on the continent, and that we would ensure that sort of accountability over time. Now, one of the things that is sometimes misunderstood is that relationship between the European Court of Human Rights and the Council of Europe. Okay, so the Council of Europe is the international organization, now comprises of 46 member states since 2022 when Russia was expelled, but we can come back to that. But the court is independent of that. It sits within the framework, but it's independent of that. Having said that, there's this kind of symbiotic relationship between the two. So when the European Court of Human Rights, for example, issues a judgment, it doesn't really follow up in terms of, is that judgment being implemented? It transfers the case over to the kind of political legal forum within the Council of Europe, called the Committee of Ministers. That's representatives of all the member states who hold each other to account for implementation. So it's a very interesting process, and it really, I suppose, that's where politics and law interact, maybe even clash. But it can also be seen as its strong point, because it empowers states to have that sort of peer review function and to take ownership of the judgments that they're required to execute, and so on and so forth. So that's kind of a general, in a nutshell. And I suppose the last thing I would just say is, just in terms of the ongoing relationship with the European Union, they are separate organizations. So, I mean, for anyone who is looking from the UK and thinks that Brexit isn't complete until you leave the Council of Europe, no, it's a different organization. But there is a strong relationship between the two. And in fact, the Lisbon Treaty provided the basis for the EU to actually accede to the European Convention on Human Rights, recognizing that it is so fundamental for any kind of well-functioning democracy, and it's part and parcel of accession processes and so on and so forth.
But it has been incredible, hasn't it, to see the way that the council and the court have made such big contributions to European democracy and human rights. What would you say are the particular standout cases, for example, that many of us sort of now see in action in our lives, which were essentially decided by the courts rather than by national institutions?
Well, there's so many, James. I mean, over the last sort of 70 years or so, we've seen cases dealing with everything from whistleblowers to domestic violence to, protecting the environment, the national minorities, media freedom. I mean, really the whole panoply of rights. But I mean, I'll give you a flavor of some of them. There was a case, for example, good one in the UK, which was related to the disclosure or non-disclosure of journalistic sources, which is, of course, is considered in media circles now as absolutely something that is sacrosanct, that you wouldn't be required to disclose your journalistic sources. But this case made it clear that, unless there's an overriding public interest, journalists shouldn't be required to disclose their sources. That's one example, and that's had very significant impact in terms of freedom of expression throughout Europe. When it comes to issues of Article 3, cruel, inhuman, and degrading treatment, another British case is the Suring case, which was from the late 80s, and this essentially was around the obligation of states not to essentially return somebody to a place where they might face the death penalty. But in specific terms, it was actually more around, not actually receiving the death penalty, but that whole process of potentially being on death row for a prolonged period of time. And this was really important because although the Council of Europe was moving towards becoming a death penalty-free zone, this absolutely underlines that. And from that point, I think, on, really emphasized that this question of death penalty is sine qua non for membership. So, for example, Belarus is one of the only states that is not a member of the Council of Europe, precisely because they still maintain the death penalty on their statute books. Then from other aspects like personal liberties, you think of the Norris case in Ireland in 1988, which followed a similar case in Northern Ireland, the Dudgeon case. And this was about, the criminalization of homosexuality. And in a sense, though, Mr. Norris, who wasn't, in a sense, criminalized, he brought the case on the basis that it was a continuing unjustified interference in private life. And he won the case. And that ended in the full decriminalization of homosexuality in Ireland in the 1990s. Turn then to more recent sort of cases around, let's say, violence against women. You've got the Opus case in Turkey, which was related to a situation where a woman and her mother were subject to violence by the lady's husband, which was reported to the authorities, but there was no adequate follow-up. And as a result, Turkey was found in breach of the convention in that regard. The impact of that case was really to develop a whole new treaty framework called the Istanbul Convention on Violence Against Women, which had an enormous effect right across Europe in all of our jurisdictions. Not without controversy. In fact, there's been some that have talked about withdrawing from the convention, but nevertheless has had a very, very significant impact. And then the last case I'd maybe refer to is on the interstate side, because individual cases is one thing, but it's also possible for a state or multiple states to bring a case against another state or potentially multiple other states. And a very prominent one that was just pronounced upon earlier this year was the Ukraine, Netherlands versus the Russian Federation MH17 case, which related to the downing of the Malaysian Airlines MH17 in eastern Ukraine by the little green men who were under the effective control of the Russian Federation. It found a litany of violations, but in particular, it found this idea that, you know, violations can occur even in territories that are not, let's say, your normal territory. They're a part of a territory that you occupy or you effectively control. This is a very important case because, in a sense, it also bridges that gap between human rights law and international humanitarian law. There are some quarters that say these two are separate bodies of law, and in times of war, human rights, we can't speak about it. In actual fact, this makes it very clear that they're inseparable regimes. So, James, I suppose I'm trying to say is across a vast range of areas, the court and the case law and the convention has had a profoundly important role to play in terms of developing democracies that we enjoy today. And almost it's actually almost as a result of its success and its embeddedness that we have now become complacent. And in some jurisdictions, we're talking about, do we really need it? Isn't our national legal order sufficiently strong and robust? But in actual fact, what we've seen, I think, in the last number of years is we cannot take our progress for granted. We cannot take our progress for granted, our allies for granted, our peace for granted. And we need to ensure that we have very strong checks and balances and systems to preserve the democratic gains we've made over the last 75 or so years. And the European Convention on Human Rights is absolutely central to that process.
You brought up some of the criticisms, and I'd like to sort of just come back to that maybe in a minute. But one of the other things which I think is really interesting is for those of us who work on international relations and conflict. I mean, you know, you presented a very good picture about, you know, how it's managed sort of human rights in a variety of areas. But we've also, you know, you and I have worked extensively on Southeast Europe and the Balkans, for example, and the court has had a couple of absolutely sort of crucial cases which come straight to mind. So, for example, I'm talking to you from Cyprus, the Loizidou case, which was a very important case where a Greek Cypriot refugee took Turkey essentially to the court over the loss of use of her property here and won. And this, in fact, forced Turkey to make some radical changes because, as you sort of mentioned, I mean, applying and adhering to ECHR rulings is now a component of EU membership. So Turkey wanting to join the European Union was forced into it. But I'm also reminded of another case, which is Sejdic-Finci, which is incredibly important. And I think in many ways shapes a lot of how we think about minority community rights in Europe. And I think this is a case that you sort of know quite well and from your work in the Balkans. So are there other cases along with that that you would highlight, which would say, look, this, you know, the court has played a really important role in sort of conflict management? I mean, you mentioned the Ukraine, Netherlands case against Russia, but some of the others that might spring to mind.
Yeah, well, James, you're right. And in a sense, that's where the rubber hits the road in the situations of conflict, where there's really, I mean, there are several challenges that face the court. Let's just enumerate some of them. I mean, one is the lack of an enforcement mechanism that goes beyond diplomacy. We don't have a human rights police force. Maybe I'd love that. Maybe not everybody would, but we don't. So we rely obviously on this idea of good faith and so on and so forth. That is a definite weakness of the system. But you can also consider that maybe it's also part of the strength to allow the diplomatic opportunities to move things forward and so on and so forth. But The second issue is the question of how long these cases can sometimes take. To get to the court in Strasbourg, you have to have, effectively used up all your legal avenues in your home country or in the respondent state before you come to the court in Strasbourg. And even then, a case in Strasbourg might take years before it's pronounced upon. So there are definitely genuine problems, even outside of situations of conflict. But when you get into situations of conflict or immediate post-conflict, it becomes even more problematic because of this question of, the legitimacy of whoever is in control and so on. Like you mentioned the Northern Cyprus cases, first of all. So the Louisidu case related to the enjoyment of property, which is a very important part of the convention system as a protocol. And in many ways, it's deeply unsatisfactory what's happening in Northern Cyprus, because you have a series of cases, Louisidu, Demopoulos, Zines Arestes, and several other cases which relate to this issue. And the court and the committee ministers have kind of weaved a path over the years. The situation is very, very simple, that people should have access to their property and the freedom to enjoy their property. The way the cases have gone in that situation was to set up the immovable property commission as a way of compensating people for not having access to the property. Now, some would say that that's a cop-out, that that's simply trying to buy away the problem and not actually being operating in good faith to give access to properties again. So there's lots of questions there. There's also questions around what kind of capacity a certain entity has to execute a judgment. This immovable property commission set up in Northern Cyprus, territory that's occupied by Turkey. Is that considered to be an effective remedy? And it was declared as such under the Demopoulos case. It's very complicated in that regard, and it's taking far, far, far too long. Some of these cases are 20, 30 more years, and it doesn't look like there's a very easy solution to them, even when it comes to the paying of reparations or what we call just satisfaction, compensation. Turning then to the Bosnian case, Sejdic and Finci, it's an excellent example, James, because of course, we're in a situation right now where Volodymyr Zelensky and many other actors are in this very hot pot of trying to discuss what peace might look like. Ceasefire first, peace later, and the long-term relationship with Russia. And the temptation in an immediate peace process or peace negotiation process is stop the fighting. Stop the fighting maybe at all costs or any cost. If we've learned anything from Dayton, the Dayton Agreement in Bosnia is one should be very careful about that. That, there was an agreement in the Dayton, as part of the Dayton process, that, certain high offices would be reserved for one of the three so-called constituent communities in Bosnia at the time. And what that de facto does then, or de jure does actually, is it excludes others. So if you're Jewish, or you're a Roma, or you're Turkish, or you're some other kind of minority group in Bosnia, that you are de jure excluded from offices. And the Sejdic and Finci judgment was crystal clear that Bosnia needs to amend its legal code and its constitution to allow for anyone to have access. If this is going to be a democracy, if it's on an EU path, that this is a requirement. But we've seen almost no progress on that case in the last number of years. So that's another example. But then you also have cases where the court can be criticized for either having too expansive an approach, in terms of affording rights to victims of airstrikes in northern Iraq, such as al-Sqaini, or having too narrow an approach. For instance, when the NATO bombed Belgrade in 1999, and people lost their lives also there, and the court famously said that it was the Bankovic judgment, famously said that no, an attack from the sky doesn't trigger effectively a jurisdictional link. So it essentially said that case couldn't go any further. It's extremely difficult. The cases related to conflict zones are extremely difficult. One last case that I would just mention, because I mentioned already the Ukraine-Netherlands case against Russia, which I think is an excellent judgment, very difficult one, but an excellent judgment. But just before that, a couple of years before that, we had the Georgia versus Russia 2 case. And in this case, the court famously said something really quite controversial, where it said that in a context of chaos, this is the way it described it. So there's a battle going on. In a context of chaos, it's impossible essentially to say who's in control. And if If it's impossible to say who's in control, then it's impossible to say who's actually responsible for human rights violations. Some people would say that that was the court committing the mortal sin of legitimizing a gray zone. The court saying that, sorry, it's too complicated for us to figure this out, therefore human rights more or less doesn't apply. I mean, in general terms. It clarified that in the Ukraine-Russia judgment. But I suppose the picture I'm trying to paint to you, James, is extraordinarily complex. If you look at the case law in relation to conflict over the years, the court weaves a channel that is not linear, sometimes going back on itself, and it is put in a position that it should never be put in. These are political crises that need political solutions. The European Court of Human Rights is never going to be able to resolve conflict. The European Court of Human Rights can just do its best to interpret the convention based on the facts that it's presented with. But it is, in a sense, a pity. I mean, on the one hand, you could say a pity. If you wanted to be a bit dramatic about it, you could say it's almost a weaponization of the European Court of Human Rights to use it when it comes to conflict zones, because it simply can't have the desired effects that we would all like it to have.
Andrew, I think that's a really excellent point, and I'm sort of reminded of a couple of examples. I think the fact that you mentioned Sejdic-Finci, which is an incredibly important ruling, but of course here we are, almost 16 years later, where there hasn't been progress made towards implementing the requirements that the court put in place to say that there needs to be constitutional change. And, I'm reminded of certain other cases. I mean, Cyprus obviously is a case I'm very interested in. Loizidou was very important. Dimopoulos was actually really important as well, because it sort of said, yes, individuals have a right to enjoy their property, but they don't have a right to demand under what authority they enjoy that property, which I think is really interesting, because that can also have quite a big effect, in terms of people who are displaced. You can go back to your homes, but you might just have to accept the political authority that's established itself there. So it's absolutely fascinating, and we could talk about so much of this for so long. But I think what are some of the main cases that are on the agenda at the moment that you think are particularly interesting and we should sort of be keeping an eye out for?
Well, I suppose when it comes to broader issues, there's lots, of course, of cases at the court, or have just been pronounced by the courts, that they're like an open question. Several cases related to climate and the environment and human rights. For instance, one very prominent case related to Switzerland, Klimas and Jornen, that the Swiss, very uncharacteristically, the Swiss authorities kind of came out and said, well, we take note of this judgment, but we think we're doing the best we can, and therefore, there's nothing more to be said about this. So really problematic when it comes to the sort of implementation of judgments and where we go from there. But I think more broadly, James, the question is less about the court and the cases that it's considering, and more about the broader context in which the Council of Europe and the court is operating. And I think that, there are major big ticket items on the agenda related to AI and human rights, climate and the environment. But the biggest one of all is clearly Ukraine, and the position of the Council of Europe vis-a-vis peace, justice and accountability in Ukraine. The Council of Europe has a lot on its, I suppose, agenda in terms of what it can do to be part of this process. It's quite a dramatic shift, by the way, of policy, because for the past almost 70 years, there's been a reluctance to recognize that the Council of Europe had any really direct role when it comes to conflict or post-conflict, even though, of course, the Council of Europe was involved, has offices in Kosovo, Bosnia, former Yugoslav countries. In fact, I worked for the Council of Europe office in Kosovo for 5 years. And it's doing fantastic work in cooperation work, working with ministries in terms of trying to adhere to Council of Europe standards and so on. But there was always this reluctance from states to, in a sense, imply that the Council of Europe might have a role that should be normally dealt with by the UN or by the OSCE or by others. And they refer back to this clause in the statute that says that the matters of national defence don't fall within the mandate of the Council of Europe. Now, this has been widely misused as far as I'm concerned, because, even in the 50s, it was made clear that that was all about a European army. Nobody wanted a European army to develop, and they didn't want the Council of Europe to be the institution that would set up a European army. It's kind of laughable when you know what the Council of Europe does now, but nevertheless, that was the thinking at the time. What was made very clear, though, those days was this does not mean that the Council of Europe has nothing to say when it comes to situations of conflict. Because actually, when you think about it, when is there a worse time for human rights, democracy, and the rule of law? Well, it's when there's a conflict. So I think that this is really interesting now to see that the Council of Europe has pivoted so dramatically to focus a massive amount of political energy on Ukraine and the accountability process. And we can speak about that if you like, James, just in terms of what kind of mechanisms have been put in place. I suppose there's been three key avenues to this. One is the immediate response to the aggression on Ukraine, which was to set up a so-called register of damages, which has collected now, I think, something in the order of 85,000 individual claims, has 44 states, not just Council of Europe member states, but others supporting it. This is learning from the lessons from Bosnia and the former Yugoslavia and other places where there's been conflict, where gathering evidence immediately, lodging claims immediately is so important for any possible future reparations mechanism. So that was step one, the register of damages. Step two was the International Claims Commission. And that literally, as we are speaking now in The Hague, the International Claims Commission is being established with the signing of the new treaty. It literally is happening this very moment. And there is something in the order of 35 states today in The Hague signing that treaty. And the final leg of the stool is the possible special tribunal for the crime of aggression. So the big question being, well, if the Russian Federation or any state can get away with a full-scale aggressive war, invasion against another sovereign state, with full impunity, without any accountability, where does that leave the international rules-based order? So some states would feel very strongly that the special tribunal is the very least that can happen, and that would focus on the highest level of leadership in the Russian Federation, not to talk about foot soldiers and so on, which, in some cases are going through the Ukrainian judicial system. But I say all of this to emphasize two things. On the one hand, this puts the Council of Europe right front and center when it comes to issues of accountability and justice in Ukraine. On the other hand, there are enormous questions about whether any of this will be successful, because this is so much dependent on a peace process that is being negotiated between, it seems, the United States and Russia, and also requires funding to actually have some sort of reparation. So there's lots of questions and risks ahead. And then the final thing I would just say is, all of that being said, where does this leave the broader mandate of the Council of Europe? Is there a risk that the Council of Europe becomes the Ukraine Accountability Organization, as opposed to dealing with all of the broader issues that it deals with across the 200 so conventions, across 46 member states, each with their own national challenges and so on. So that's a bit of a picture of where we are at the moment. Lots of issues to be dealt with, and lots of uncertainty, I would say.
I hope you're finding this useful. If so, please do give it a like and perhaps subscribe to the channel if you haven't already. It all really helps. Many thanks. And now back to the interview. You raised a really interesting point about Ukraine, because, of course, we had these, 27 points that Trump had put out in his original peace proposal. And several of them seem to be absolutely contrary to our understanding of a peace process. And it would seem open to claims put before the court. I'm very minded of the fact that essentially Russia would have been let off the hook for human rights abuses. Would that have any validity if that were written into, just say that Ukraine were to accept that and write it into a treaty? What would happen if ordinary Ukrainians said, but this goes against fundamental principles of human rights, and I want to take it to the court?
The devil will be in the detail, of course. I mean, the point is, though, if the Ukrainian state was to accept effectively a high-level amnesty, whereby it would not pursue claims against the Russian Federation, I'm afraid it would be very difficult to pursue that any further. Right. Yes, it is possible that you could, under universal jurisdiction or so on, try to still prosecute. Some states could take initiatives to try to still prosecute certain individuals, but it would be extraordinarily difficult to do that. So, I think that we also need to be realistic about the situation we're in. Russia is no longer a party to the European Convention on Human Rights. It was the only state in the history of the Council of Europe to be expelled. Mind you, Greece came very, very close. Greece withdrew and then acceded. So it's the only country to have ever acceded to the European Convention on Human Rights twice. For the next table quiz you're at, you can have that in your back of your mind. But Russia is not a member of the Council of Europe. It's not a party to the convention. It's not a party to the ICC, the Rome Statute of the International Criminal Court. Anything that happens in relation to accountability needs to be done by the international community, ideally a very strong critical mass of the international community. So if you have a situation where America wants to essentially let Russia off scot-free on the one hand, or Ukraine signs some document that accepts this large-scale sort of amnesty, which I cannot imagine ever happening, then it's very difficult to imagine any kind of pursuit of accountability. Sure, on an individual basis, if there are soldiers captured and there's a case put before the courts in Ukraine and so on, but it would be very difficult to pursue otherwise. So that plan that was presented was quite shocking, James, because on almost every single point in that plan had major problems in relation to territorial integrity, accountability, reparations. I mean, even to think about this from a strategic point of view, from Europe's perspective, there was a point in there about, a mediating forum between NATO and Russia, where the United States of America would be the chair or the mediator, which in itself is quite incredible to think that America doesn't even see itself as part of the NATO camp anymore, but something different. So there are very big questions. Look, it remains to be seen how this will all pan out. By the sounds of things, we're heading towards a ceasefire, but really one hopes that whatever agreement is made, it's one that is fair to Ukraine, to the people of Ukraine who have suffered so tremendously over the last four years. When it comes to territorial integrity, when it comes to accountability, reparations, and so on and so forth. Sure, concessions are probably going to have to be made and hard choices, but this should not be a capitulation, because if it happens in that way, James, we can be certain that history will repeat and we will see this happen again, and it will send an incredibly dangerous message right throughout the world, not just the Russian Federation.
I completely agree. And it's something that, I often bring up on the channel of why I think Ukraine is so much more important than people often realize. This is not a localized European conflict. Many of the decisions that will be taken around this, have the potential to fundamentally affect international law in so many ways. But Andrew, moving on, I mean, it's interesting that obviously the council, the court, is so important in how we think about Ukraine. But in many ways, it's a very different issue, which is bringing it to the front of international news these days. And that is the question of migration. We know that migration has become a huge political issue in a lot of countries. We can see that in the United States, but obviously in Europe as well, in the United Kingdom. And what's really struck me is that there has been growing talk, and you alluded to it earlier about the second Brexit, this idea of leaving the court. This is something that seems to be entering the political mainstream in Britain, but it's not just in the UK. There seems to be real talk about reforming the European Convention on Human Rights, updating it in order to tackle these migration issues that are becoming sort of political footballs and hot potatoes in countries. Perhaps you could sort of just delve into that a little bit and explain what are these issues that are emerging. Can the convention be changed? What do these countries seem to have in mind? Because it does seem to be something that's coming much, much more to the fore of the political agenda.
Yeah, it's absolutely become almost a mainstream issue. It's quite disappointing to see that it's presented as a kind of a dichotomous thing almost. In the UK in particular, it's either you're in or you're out, which is quite disappointing because, of course, there's a whole spectrum in between. I think it seems to center on the idea of migration. I think in particular, irregular migration where states feel that there's an enormous public policy challenge in some states, which is quite real and immediate in terms of housing, healthcare, public services, and so on. That this is the way it's presented, that, well, if we didn't have this influx of irregular migrants and asylum seekers, that we would have less of a problem. That's my understanding of it. So in practical terms, what some states are saying is, well, the European Court of Human Rights is to blame for this, which of course is actually a fallacy. It's completely a fallacy to say that, because in actual fact, what the European Court of Human Rights provides is this idea of subsidiarity and margin of appreciation. The reality is the court is afraid to rule against countries like the UK or others that have consistently spoken strongly against some of its judgments over the years, for better or for worse. It's highly deferential to what states do. It is not impossible to deport a foreign criminal. It is perfectly possible to deport a foreign criminal. It is just very, very specific, extremely narrow circumstances in which you would not maybe be able to deport someone. For example, I referred to the Sering case earlier around the death penalty, but it's more around refoulement to a place where someone might be subject to torture or so on. So very specific circumstances. Generally speaking, it is no problem whatsoever. Likewise, there's a conflation between what an economic migrant is, who in principle doesn't give rise to a human rights question. If you're an irregular migrant, an economic migrant, and you're not legally in the country, goodbye. That is not a human rights issue per se. It may have elements, but generally no. And asylum seekers, who are by definition coming to seek refuge because of a well-founded fear of persecution or whatever. So states are presenting this sort of boogeyman approach where the court is what's limiting us from deporting these bad guys. The court is the reason why we have this influx of migrants. They're misusing the convention. It's deeply disingenuous, James, I must say. In reality, it's probably more related to national jurisdiction issues. Either the courts in the country, for example, in the UK, maybe that the courts in the UK are being hyper conservative by applying the European Convention on Human Rights that go in a way that goes beyond what the European Court of Human Rights itself would say. And this is true. It definitely is. Or it's a broader public policy question where there is a challenge of housing and healthcare, which is nothing to do with the European Court of Human Rights. It's a question of policy decisions over many, many years. Or the third possibility is that this is just populist politics, that this is just pandering to right-wing politics who really like the idea of finding an external target to externalize the problem. Regardless of the motivations, where we are now is as follows. In May, there was a letter of 9 states written openly, which said, we need to find a rebalancing of rights, specifically focused on Article 3 and Article 8, regarding inhuman degrading treatment on the one hand and private life on the other hand. We need to have an open-minded conversation about the convention. We need to essentially give more liberty to states. That then has evolved over the last number of months into a process that was agreed last week, ministerial meeting in Strasbourg, where states unanimously agreed to set up a intergovernmental discussion on the convention. Great, that's really good. It's something that is part and parcel of the convention system. You asked me in the introduction there, is it possible to change the convention? Yes, that is fundamental to the whole system. The whole system is built on the idea of a continuous dialogue and change over time and so on and so forth. However, alongside this unanimous decision was a dissenting opinion, so-called joint statement. 27 states that issued this far-reaching statement that really struck right at the basis of the independence of the courts, right at the heart of what the convention tries to achieve, said really quite challenging issues around effectively creating a 2-tier rights system. So if you're in a one category of persons, migrants broadly conceived, which could include refugees, irregular migrants, who knows what, you should be afforded fewer rights protections than everyone else. And this is deeply, deeply problematic. It is indicative, though, of the political direction of travel. 27 states now, we'll see if that increases over time. I suppose the process now is that between now and May, There'll be some technical work discussions on all of this to try to come to a political declaration that would, in a sense, influence how the court looks at these things. Now, why is all that matters? Why does all that matter? Well, I suppose it shows a changing environment in terms of the commitment to the convention system. But much more concerning for me is that it fundamentally undermines the independence of the European Court of Human Rights. It is perfectly acceptable for states to discuss the convention. In actual fact, myself and others repeatedly call for more political engagement with the system, so that it's not this kind of situation where you go to the convention and it's a smash and grab. Oh, we don't like that now, so let's change everything. It's perfectly fine to do that, but in a way that respects the fundamental principles of independence, judiciary, rule of law, and basic principles of human rights. At the moment, the declaration is really problematic from that perspective, and we need to be extremely careful about, I think, where we go from here. If we send a message as European states that when the going gets tough, we simply lower the standards for some people, we other them, we say those guys don't deserve as much rights as us, we're going to have a different standard for them. What kind of message does that send to authoritarian regimes around the world, in Europe or elsewhere? It's really deeply, deeply problematic. And my concern, James, is that this decision that was made this week by the 27 was done without really an appraisal of the evidence. The evidence is that the court doesn't actually restrain the states as much as they say. The evidence is that the migration challenge is much more of a national issue than it is a European Court of Human Rights issue, and that the system is quite open to having discussions about the future. This is not some sort of radical closed-door scenario. So I would urge a high degree of caution for the states as they move forward over the next few weeks and months in this process.
Andrew, I mean, it's been incredible talking to you, and I've got one final question, which is a little bit of a look ahead, because we are obviously living in very worrying times in all sorts of ways. I think, you've highlighted how the convention is coming under real pressure. We've already seen how Russia has been expelled from the Council of Europe. There's been talk that other countries could either be expelled or could withdraw, simply just saying that, look, we just don't want to be part of this anymore. For example, this has been a question that has occasionally, we've got Britain obviously talking about this over migration. Turkey has also raised this issue over many cases that it's faced on human rights. There's been talk about Azerbaijan in the past and maybe at the present. Hungary is another country that one could imagine that this could very well apply to. How worried are you about the overall structure of human rights in Europe and the current direction of travel that we're seeing?
From my perspective, controversy and friction and tension and disagreement, that's part and parcel of the business of international relations, and specifically international human rights law. So I'm not concerned really about that. I think we should be ready to engage in robust dialogue. We shouldn't be afraid of dissenting opinions. In actual fact, James, my personal opinion is that somehow we have found ourselves in two different tracks of discussion, that the sort of libertarian human rights people are speaking on one channel, and the people who are slightly more socially conservative, maybe with legitimate concerns and views, are speaking in another channel, and there's no crossover between the two. That's really deeply problematic. We need to be able to find that middle ground where we're discussing, debating, and finding solutions. So I'm not concerned about the friction, so to speak. What I am concerned with is that there is clearly a backsliding when it comes to standards. And not standards that are at the sharp end of human rights development around AI and human rights or environment and human rights, which I can understand. When there isn't a broad consensus on something, they can be more contestable. I'm concerned that the basics are being now questioned. Basic principles of rule of law, basic principles of fair trial, basic and absolute principles around prohibition of ill treatment. And what next is the question? What kind of precedent is this setting? Like, will we get to a point where journalists are being more and more repressed around freedom of expression when they speak out about particular issues, or civil society groups, or national human rights institutions, and so on? So for me, when the discourse has gradually and in a kind of civilized, sophisticated way slipped over towards the right, where there's a shrinking space for a sort of mature discussion on human rights and rule of law topics. And when the fundamentals are being questioned, that is real cause for concern. And that's why I think the next 5 months leading up to the ministerial meeting in Chisinau, when we talk about the European Human Rights Convention, this is the moment for states to stand up for these principles. This is the moment for them to show and clarify their credibility on these issues, because the consequences could be quite far-reaching. I don't think we're going to see a situation where there's going to be a cascade of states leaving the Council of Europe. I'm more concerned that states will remain part of the Council of Europe in bad faith, and they will erode the standards from within. And that does seem like a more and more plausible prospect. And the last point I would make is international law will never be broken by the big powers, James. It'll be broken by the smaller states, the majority, who stay silent, who don't stand up for these standards in the time that's really required, that accept this othering of some population, some people over others, who accept the gradual erosion of the fundamental principles. We cannot allow that to happen, because frankly, all of our peace, democracy, prosperity, and so on really depends on it.
Andrew, thank you so much. That was incredible talking to you about it, and I think you provided an amazing overview of what I think we can both agree in every single possible way in incredibly important organizations for all of our rights, democracies in Europe. So thank you very, very much for that.
Pleasure, James. Thanks a million for the invitation.
I hope you found that useful. If so, here are some more videos that you might find interesting. Thanks so much, and see you in the next video.